Go on the record, Tony, on DC 234103. DFW Movers and Erectors, Inc. versus Star Indemnity Liability Company. Counsel, make your appearances.
This is Sarah Mocamp-Carr on behalf of defendant Star Indemnity and Liability Company.
This is Amanda Fulton on behalf of plaintiff DFW Movers and Erectors, Inc.
All right, let's proceed.
Okay. By way of background, this is a dispute involving an insurance company, our client Star, and their insured DFW Movers. DFW made a claim under an insurance policy that our client provided to them for the policy period of April 15th, 2020 to April 15th, 2021. The claim was based on a wind and hailstorm event that happened in the summer of 2020. So since this was a force of nature event, the claim has to meet certain requirements of Chapter 542A of the Texas Insurance Code. One of those requirements is providing a 60-day pre-suit notice letter that sets forth specific requirements that have to be alleged in that notice. Plaintiffs provided a purported notice letter. However, it didn't meet two of the requirements set forth by the statute. The first of which is that it didn't claim the specific amount alleged to be owed by our client Star. So the letter states that our client owes $250,494.60 for estimated damages. However, they then go on to state several caveats of amounts that must be subtracted and added to this figure in order to determine the actual cost owed. So they say less the deductible, prior payments, any policy provisions governing the payment of replacement cost. And courts have found that when these caveats are given or the specific amount alleged is not claimed with precision or specificity, this is not sufficient to meet the requirements of Chapter 542A. So a failure to state this amount bars plaintiff from recovering attorney's fees incurred after the date of filing the plea, and there's no exception when the claimed amount is unstated but calculable. So just because Star can go forward and try to apply the deductible in the manner they think it fits or apply policy provisions they believe apply to the claimed amount, that's not really the spirit of this requirement. The requirement really is so that our client Star knows the entire amount claimed, how they're applying policy provisions, so that ideally this matter would be resolved prior to any litigation filed, have that 60 days prior to the filing of any lawsuit in order to try to resolve based on a true and accurate amount. And we recently filed a notice of supplemental authority in a case, Westchester Surplus Lines Insurance Company case, where that court reiterated this precise requirement. And the court says that it does not permit a claimant to equivocate or suggest an estimate or offer a placeholder sum that could be changed after further investigation takes place. So this purported notice letter in the instant case does exactly that. They offer these caveats that I already stated, and they also state that they are reserving their rights to all other damages and penalties for which Star may be liable, and reserves the right to adjust the amount. So that's the exact type of language that this Westchester case states is not sufficient in order to meet that requirement.
So I'm going to go ahead and share screen. Is this the portion of the contract that or the notice letter that you're talking about?
Yes. Yeah.
Okay. So it's $250,494.60 for estimated replacement costs of repairs to the loss, less any deductibles, that prior payments or policy provisions limiting payment or replacement costs.
Yes.
Okay.
And then
so you have a case that says that that's not precise enough, because it would seem like you would know what the deductible is, what the prior payments are, and if there's a policy provision limiting payment. So I guess I'm not sure. I guess show me this Westchester case that shows what the letter said in that one.
So that provision along with that,
Go
or
ahead
that,
and share screen that.
okay, one second, let me try to pull that up. That provision along with the statement under number 4 of the letter you were just looking at, where they stated that they're reserving the rights to edit it, also, we would argue, limits it. One second.
Okay, but we'll take a look at this case. Is this case out of the Dallas Court of Appeals?
It's out of Amarillo, Judge.
Okay. Yeah. Do you have any cases out of the Dallas Court of Appeals on this?
We don't, yeah, like you said, that case is out of Amarillo. We have cases from other parts of Texas similarly requiring this precise requirement, but perhaps not.
Let's share screen your best case that's closest to this one.
Okay.
Unless Ms. Fulton, you agree, I guess.
Judge, I don't. I would, for efficiency's sake, I can make argument, or we can wait until that share screen is up on the screen.
That's fine by me. If you
So,
want to
Judge,
go ahead.
sure. The case that opposing counsel is citing to this Westchester case out of Amarillo is completely distinguishable. In fact, it is a case where plaintiff's counsel sent a $20 million demand letter to a carrier. And in the letter states, we cannot and will not resolve this dispute for the amount of damages and fees listed above. They then went on to file suit for $100 to $150 million on the same claim, and essentially admit in their letter that they undervalued the demand letter, so they didn't get popped at trial for sending too high of a demand letter and not meeting those damages at trial. It's completely distinguishable. And when you read the claimant's letter, it's very confusing. There's 2 different dates of loss. It's completely distinguishable from this case. Like I said, they're sending out a demand letter for $20 million and filing suit for $150 million. In the instant case, we have a $250,000 estimate that was provided to the insurance company prior to our involvement. Our demand letter is for $250,000. Our lawsuit is for $250,000. Our initial disclosures are for $250,000. Further, our 542 cites any prior payments or deductible amount. What's frustrating with this whole issue is when our firm gets retained, we send a letter of representation to the insurance company asking for a certified copy of the policy so that we can cite those numbers like the deductible with specificity and with correctness. We're routinely ignored by the insurance company. So we then send a demand letter. In this case, there's no dispute. There are no prior payments. So this whole, we don't know how to calculate the damage model is just asinine, really. There are no prior payments and the deductible is $10,000. So once you've had a chance to look at this Westchester case, it's pretty egregious, in my opinion, on what plaintiff's counsel did in that case. It's completely distinguishable from here. And I would encourage the court to read it because the demand letter is quite off. There are other cases cited in this supplemental authority by defense counsel that we can talk about in this hearing as well that are distinguishable.
Go ahead and share screen the case you want me to look at, counsel.
Oh, I'm getting a notice that only the host can share in this meeting.
Go ahead.
Oh, okay, I see. Okay.
Try not to die, okay?
here we got, this case is a case we cite, Gilbane Building Company. This is out of the Southern District of Texas. This similarly sets forth the standard to cite with specificity the amount owed. So a court has held that a pre-decision cost estimate cannot serve as pre-suit notice. The cost also fails because it communicates plaintiff's total costs instead of the amount alleged owed. Basically, this case, along with Westchester and other cases, are really getting at the precise requirement. So, right, there is the line that says they're limiting it by policy provisions, by deductibles. Again, that's something that the insurance company can apply in the manner in which they find to be appropriate. But if there's a disagreement about how those provisions apply, which is the heart of many insurance disputes, then the insurance company deserves the fair notice to know what that claimed amount is and how those provisions are being applied. And further, like I said, under Section 4 of that list they go on to reserve to change it in other ways based on future investigations, which again is just not the spirit of this letter. The letter is supposed to give the insurance company a fair notice in order to resolve disputes prior to litigation. It's not just a checkbox requirement of providing any figure they deem fit.
Can you show me the rest of this opinion, because I can only read part of it?
Yes.
This is a federal judge.
Mm-hmm. Yes, Southern District of Texas, yeah.
And this is a case where they want to preclude attorney's fees, is that right?
Yeah, so as required by the code, if they don't meet these requirements, attorney's fees are precluded by statute.
Judge, if I may.
Sure.
So I have the case pulled up as well. If I could share my screen, if you don't mind.
Go ahead.
So here's Gilbane. So it's out of the Southern District. It's Judge Sim Lake. And if you notice, there's no demand letter sent whatsoever. Again, I would encourage the court to read it. There's a series of communications, emails, and spreadsheets sent between plaintiff's counsel and the insurance company in this case. There is no demand letter sent whatsoever. This is completely opposite of the situation we have here. Again, I readily agree with the court that it should be set, attorney's fees should be set aside because they completely ignored sending a demand letter whatsoever. Here we have a demand letter sent that has a specific amount. So I would encourage the court to read that case. And I think you'll see clearly that it doesn't apply here. It was simply emails and spreadsheets sent back and forth where plaintiff's counsel then tried to say that that was sufficient enough to create a demand letter. And the court said, no.
Okay. All right, let's kind of chat real quick. So I'm going to share screen this. I'm going to deny the motion. Have you submitted, Ms. Fulton, have you submitted an order on that?
Judge, I believe we should have. If not, I can get one.
Can you just see here? I've
hearing.
So if you've done it, I can go ahead.
I'll say my paralegal is usually very good. But if he did not get an order,
I'm not saying he didn't. I don't know. Is it here?
I don't see it.
Is it this thing here?
Outside proposed order 5:30. No, it would have been after 6/9. So I'll get one on file.
Well, just let me check. You said it would be after 6/9. Yeah, I don't see an order.
Let me make sure he didn't include it with the response. Nope. So we will get an order, a proposed order, Judge.
Okay, and then you also submitted a. Just real quick. Did you submit an agreed scheduling order on 7/17?
Yes, Judge, we were on the DWAP for today. I think that's been pushed off, but if we could get that DCO signed off, then it.
Yeah, I'll go ahead and sign that right now. Rhonda, this case needs to be set for trial.
Yes, Judge, what case is that? I'm sorry.
DFW movers and erectors.
Got it. Okay.
And I'm gonna go ahead and sign the order right now.
And we also had one more matter set for hearing today, the motion to dismiss of Richard Swink, which is unopposed.
Yes,
Okay.
Judge, that's unopposed.
And then did you submit an order for that?
I think we did.
Yes, there is, Judge. It looks like that order was filed May 1st.
Yeah. Mhm.
I'm sorry, let's do this again. So I'm sorry, I'm gonna pull this up again. So what day was there's an agreed schedule?
On May 1st is the proposed order for the dismissal of Richard Swink.
Okay, May 1st, proposed order of non-suit, is that what it is?
Yeah, I'm not sure why it's labeled like that, but proposed order of dismissal.
And let me take a look at this, make sure we hit the right thing. And schedule order we're gonna sign. Is that the correct one?
For the docket controller, yeah, this looks right.
And is that on a Tuesday? We try on all our cases on a Tuesday.
April 5th, 2024.
Yeah, that's a Tuesday.
Okay, good.
I show April 5th. Oh, sorry, that's just
July 9th.
I'm looking at the wrong thing. Yeah, that's correct. It's
Oh, I'm sorry, I already signed this. Rhonda, this should be on the trial doc.
Okay.
That's
What day
good.
are we sending to?
I signed this a while back. It's on July 9th, 2024.
Okay. Let me just check, make sure that hasn't already been updated.
It's not,
It's not? Okay, I'll do it.
Yeah.
Ms. Pinson, would you mind sending us a copy of that? I don't have that in our file.
Sure, a copy of the signed order?
Of the signed order. Yes, ma'am. Thank you.
Yes. Okay. And you were the plaintiff or defendant side?
Plaintiff.
Just send it both.
Both, okay. So,
And Judge, the order you have up is the correct order. It's an
Yeah.
agreement.
Just in abundance of caution, you may want to always put like partial or something so it doesn't accidentally get dismissed.
Oh, boy. Okay.
Okay, I think we got everything now. Okay. Anything else we need to chat about?
Nothing
I
from
think
plaintiff.
that's all. Yeah, that's all for us too on the docket today.
Okay, you guys have a great rest of your day and we'll see you on the next one, okay?
You as well. Thank you, Judge.
too.
Thank you. All right, did anyone ever show up at Discover Bank versus Bowers? Okay. All right, did you put the other, Miss Bowers, are you there?
Yes, sir, I'm here.
So did you ever send notice to the other side about the setting of this hearing? I don't, let me see, notice.
Yes, sir. the notice of a hearing was filed and sent via e-filing on July 25.
Can you tell Rhonda if that got sent via e-filing?
let's see.
Said, I can only show the certificate of service that it went to the three email addresses they have on the service contacts.
Rhonda, can you look that up?
I'm pulling it up now. Just see. For Discover Bank. I do see a notice of hearing.
But can
regarding-
you tell that the other side got it? That's what I'm trying to figure out.
Let me contact the Marissa just a second.
Yeah, just the court, Terry, may I help you?
Hi, Terry. Is Marissa available?
She's on the other line.
Maybe you can help me real quick. I'm trying to verify if a notice of this hearing was sent out. Can I give you the cost number?
Yeah, please.
DC 23-00760. This is
And
on,
what am I looking for?
trying to see if the motion to set aside notice was sent to the opposing side.
Okay, let's see. Motion is set aside. That would have been on 7/24.
Mm-hmm.
Can't tell if they sent it to the other side. We did not.
Okay.
We didn't send it because we don't send out their motions.
Got you. Okay. Just wanted to confirm. Thank you.
Yeah, I wish I could help you. I wish these people would send us stuff saying, yeah,
Rhonda, go ahead and call the other side and just see if they're aware of this hearing.
Okay. And this is,
Discover Bank.
okay, so call the process just a moment.
No, don't call the pro se, call the plaintiff's attorney.
Oh, okay, got you.
The pro se is here.
So, Judge, I have a question. If the e-service says it was sent, you're saying that technically they may not have still gotten it?
According to our clerk, it was not sent. So I don't know. You're saying it was sent. There's the clerk saying it wasn't sent.
I'm sorry, I can only go from the receipt on the back of what was filed on the 25th.
Yeah, I'm not criticizing you.
I don't know if I did it wrong, so that's why I'm asking.
Yeah, I'm not sure either. If they,
I'm sorry, Attorney Constance Monto.
okay. And what case are you calling and where are you going?
I'm calling with the 68th District Court regarding a hearing that's going on now. And the cost number is DC-23-
we're gonna go ahead and start with the next hearing, which is DC 23-1519 Weddles versus Progressive County Mutual Insurance Company. Counsel, make your appearances.
Vernon Claver, the plaintiff, Sabrina Weddles, Your Honor.
Holly Eisenhower for the defendants, Your Honor.
All right, you may proceed.
Your Honor, this is a motion to sever and abate. We've got the underlying action involved a third-party tortfeasor. He settled out for the policy limits, and then there have also been PIP payments made. After that time, I believe allegedly a claim was made with Progressive and offers of settlement was made and then reiterated numerous times, ultimately rejected. And therefore they filed suit against both Progressive and the claims handler. They have alleged they filed a deck action so they can get attorney's fees. And then they've also filed alleged extra contractual claims, including bad faith for the claims handling. And then a respondeat, of course, superior for the claims handler, Mark Durth. in this situation, we're requesting the extra contractual claims be severed and abated. And I know the court's very familiar with this because we've had several hearings with you in the past years. But to reiterate, the courts have broad discretion to sever and abate, and it's in order to promote justice for the parties, avoid prejudice to the parties, and further convenience both the court and the parties. In this situation, how severance is proper when the controversy involves more than one cause of action, which we definitely have here. The extra contractual claim in and of itself would be proper if brought in a separate lawsuit. And then severance is also proper when the claims and the facts are not so intertwined as to involve the same identical facts. How Progressive handles the claim, how they assess the damages, whether they have a duty has nothing to do with the underlying action. They have a burden to prove both liability and damages, just as they would in a regular car wreck case. And they don't even meet the threshold of duty. I guess the threshold may be moot. I mean, the extra contractual claims may be moot. If they're awarded either the same amount or under the amount of the offsets, which of course would include the policy limits here and the PIP payments, then they would not even be entitled to underinsured. So we would never even get to that point. I think the main prejudice here is the fact that an offer of settlement was actually in writing. It was made. We're entitled to keep that out in an auto case under Rule 408. And on the converse, we're entitled to defensively bring that up because in the extra contractual part, because they're saying that they were not offered what they were a reasonable amount. And we're entitled to bring the offer of settlement to show that they were. So they would be highly prejudiced if the two were kept together. So in this situation, we're asking they be severed. We're asking it also be abated. So we don't, we would have separate witnesses that we would probably have to get an expert, retain an expert, take depositions that would incur additional costs, which may be moot again if the jury and the underlying action comes back at the same or under the offsets. So we respectfully request the court sever out the extra contractual claims from the underlying action and abate that action until there's been a jury verdict entered or judgment entered in the underlying action.
Response?
Yes, Your Honor. Couple of things I want to bring up on this one first. I think that severance is proper here. I don't really think there's a good legal way to fight it, and I think that severance is probably proper. I do have some issues with what they filed here. I still have never seen the order that they're proposing that the court sign on this. I got an email on June 2nd from Ms. Ekval, but it just includes a letter. It doesn't include their proposed order. So I do think severance is proper, probably in the context of this UMUIM claim, in which we've asserted both declaratory judgment action claims as well as 541 claims. The motion makes reference to breach of contract claims and extra contract or bad faith claims handling. I guess common law bad faith claims handling claims. I don't think we've pled those, and so I wanted to make sure that the order wasn't overbroad. The other issue I have is that they filed this motion and it's got a certificate of conference on it. I mean, I've got this one email from Ms. Ekval asking about it, but I don't see any phone calls from her contemporaneously. It doesn't really meet the certificate of conference requirements for this court, which require 3 efforts to contact opposing counsel on 2 separate days and 1 by phone call. I don't have any phone calls from Ms. Ekval from that time, so I would like to have discussed this with them before. Since they set this for hearing, I'm happy to discuss it, but I think that, broadly, I just don't want the order to be overbroad, which I still haven't seen. It didn't look like they'd filed it. They sent me a letter saying, see attached order, but the order wasn't attached. I do think severance is probably proper. I'm not sure. I didn't see the law in support of the abatement of the extra contractual claims, but I do think severance probably is proper in that context, Your Honor.
All right, I'll grant the motion for severance. I'll deny the motion to abate. Go ahead and confer with each other about the order. Go ahead and make sure that the order says that this was heard on, instead of on this date, on August 7th, 2023. And Ms. Eisenhower, go ahead and share that with Mr. Clay before you submit it. And then we'll go ahead and get it signed, okay?
Okay, will do.
Thank you. Bye-bye.
Thanks.
Yeah.
Judge, I am trying to get an attorney for that other case.
I think they're here. Ms. Carter Bennett, are you here on the Discovery Bank case?
I am. I just found out about it. So let me, if you give me a little bit of time, I'll brush up.
I don't know that you guys got notice of it. The clerk said you didn't, but the plaintiff said you did, or the defendant said you did. It's a motion to set aside a default judgment.
Okay. If you give me a few minutes to get acclimated, can you put me at the bottom?
Yeah, go ahead.
Okay.
We'll do that. There's someone that says iPad 2, poo poo 2. Can you go ahead and put your name so we know who you are? And then Miss Melvin, what are you here for?
Good morning, Your Honor. I'm here on a first amended motion for judicial review for an instrument purporting to create a lien document.
Yeah, let me take a look at that. That's set at 10:30.
Yes.
Okay, Tony, let's go on the record on DC 2217212. In re, a purported fraudulent lien claim on property, my mutual freedom, aka mutual freedom. Counsel, make your appearances.
Yes, Your Honor. I am here on behalf of the plaintiff, Audrey Hogg, who is the executor of Arnold Young, that she's just changing her name per your request. Sorry about that.
Okay.
And may it please the court, I come before the court today with a motion that was, I guess, created by the county, Dallas County, to assist property owners who had their, oh, I'm sorry, I didn't know what was going on with the screen.
So I've read it. What I'm concerned about is it looks like nobody's been served in this case.
Right, Your Honor. According to the, well, so we are attempting service, but so I have 9 of these cases. So far I've gotten some of them, signed, and after I did a first amended motion. What the code says is that these hearings can be ex parte, and that the intended nature of this was not for us to have to track down basically thieves who've stolen from individuals. And so it's the code definitely allows.
Give me the code provision you're looking at.
Okay,
I'm not disagreeing with you. I'm not familiar with that. So
I'm so sorry, Your Honor. Let me just get to the presumed fraudulent. Oh, court's authority to make a rule in section 51903C. It gives the district judge the authority to make the ruling even ex parte on this particular type of motion.
51 point what?
51903.
I guess
Of
not
the government code. I'm sorry, Your Honor, of the Texas government code.
So
51.903.
okay, we'll take a look at this. It's not in O'Connor's 51 point. Let's see. Okay, let me take a look at this. Let's see if we can find it on Google real quick.
Specifically C, Your Honor.
Second.
And I can read it on the record if you,
Now, let me, I like to read it myself.
okay,
So
sorry.
it's okay. You said 51.903.
Yes. And then C is the section that gives the district judge who has jurisdiction over real property matters in the district to rule.
Okay. All right. Let me read that. Okay, I guess explain a little bit more. So why, I'm going to share screen this. So what about it makes it obviously a fraudulent lien, I guess?
Okay, yes, Your Honor. Thank you so much for pointing that out. So what happened in this particular, in this case, is that there were 9 deeds. They were all notarized by, so the notary, Belinda Tucker, they were all notarized by the same notary who also ended up, I guess, signing the deeds. What's notable is that this is not Mr. Young's signature. I've also submitted to the court experts that we paid for handwriting opinion, well-known expert. And so we submitted that handwriting report. This is not Mr. Young's signature, nor did he convey none of his properties after the date of his death. He passed away in March, and these deeds were conveyed or written up in July. I'm sorry, Your Honor, let me go and clear that up. He passed away in March of 2021. These deeds were dated back to July of 2020 and then filed after his passing in March of 2021. And so the notary on this document is also a officer of mutual freedom. So you've got a couple things going on. You've got a mutual freedom, a notary notarizing a document to herself in which she has a self-interest, which is not okay. You've got the signature, which is not correct, which is not Arnold Lydell Young's, a deceased person. And basically this code was enacted. I'm dealing with this. We're basically trailblazing in this space. The purpose of the judicial notice generally under the section 51900 was that so that people who have been defrauded of their property can actually have a remedy at law. When I first filed this type of motion, just based off of what the county said, I realized that the court may have needed more. They needed a background. In this instance, I have people who have already been indicted. I have, obviously, they haven't been to trial yet. I have deeds that were filed after the decedent's death. I have handwriting experts. And so I'm able to prove to the court that basically Mr. Arnold Young could not have, done this, especially since he was already deceased at the time. And so what I'm asking the court is that we not have to try to track down and serve persons who defrauded us of property. Like I said, I have so many cases like this, some that have already been to trial, some that just need to have a remedy at law to basically overturn some of these liens or fraudulent deed transfers back over to the rightful owners.
I guess just looking at it, I can't tell that, I mean, I've seen some before that are really fraudulent. I'm trying to remember, I've had a few of these over the years that I can't recall any that where you didn't provide obtain service. That's kind of unusual. I see that it can be ex parte, but can you do it? Yeah, I'm gonna need you to get them served, and so I just don't feel comfortable signing it based on what I can see here. So go ahead and get them served, and then we'll just kind of take it from there.
Okay, well, we'll continue to attempt that service, and we'll let you know if we're able to get to and come back before the court. I've had that in the past where some of the courts have said that. So then I amended my petition to give the authority, to give the facts. I've done more than just presented a document to the court asking for a judicial review. I've asked the court, hey, I'm giving you the entire background of this case. I'm giving you a report. I'm giving you an affidavit. Obviously, there's a remedy for the court if this were not a truth. I'm giving you indictments, information of indictments, of felony indictments. I just don't know what more I can give the court. And so that it makes it a little bit difficult and frustrating because I'm literally trying to help people who have been wronged get a remedy at law from the court.
Right, but I mean, that lawsuits, people are entitled to service and an opportunity to be heard.
Yes, they are, Your Honor, but if they're in prison or in jail or not here, or you can't find them because that's what they do if they're escaping the law, then so we're basically
forcing. There's nothing in the file that indicates that. That's what I'm saying.
There's nothing in this file, in my motion, that indicates what? That we tried to track down the folks who defrauded us?
There hasn't been a motion for substituted service that indicates that you've tried to get service and then service has been ineffective.
Because the code doesn't require that, but we have, like I said, this is one of 9 cases. Some have already been signed off on by judges. Definitely not the first time. Most of the judges did exactly what you did. They wanted service. And so I amended the motion to show that the law says we don't have to have service in order to accomplish this goal, and including sitting down with the county clerk to see, have other judges done this before me? And once I realized that, I went ahead and amended, tried to give a background, went well above board with what the basic form is that most lay people are submitting to the courts. And so I've had that in the past until I amended the motion and gave the court the authority and the background and a complete affidavit with facts from the client, the plaintiff, sorry.
Okay, great. Well, thank you so much. Just get us, service, and then we'll take it from there. Okay.
All righty. Thank you, Your Honor. Thank you.
Thank you. Have a great rest of your day.
Yeah.
All right, Miss Discover Bank versus Bowers. Are both sides here on that?
Yes, sir. Melissa Bowers here.
I'm here, Your Honor.
All right. Are you ready to argue this, or do you need more time?
I'm ready.
Okay. Tony, let's go on the record on DC 23-00760, Discover Bank versus Bowers. Counsel, make your appearances.
Valencia Carter Bennett for Discover Bank.
Melissa Bowers, pro se.
All right, you may proceed, Ms. Bowers.
So I obviously don't know what I'm doing, and I had received a letter from Zwicker last November, and I started making payments for this past due debt, and I was then served in May of the lawsuit. So I had asked previously, when I got the original letter, you can sign up for email notifications and to discuss the case, and I did, and I never received anything. So when I was finally served with the lawsuit, I was kind of at a loss because I've never been sued. I don't know what all goes into it. And since I had been making payments, I mistakenly, I guess, thought everything was fine. And so I've continued to make payments. So far I've made 19 payments, and as I emailed them when I got the notice to dismiss, I, again, not knowing what I'm doing, I thought the law firm was going to dismiss the case. So I reached out to them saying, hey, let's keep it going. I'm happy to continue to pay. And that also didn't get a response. And so, as I mentioned in my motion to set aside, one of the exhibits, I've listed all my payment schedule that I plan on making and that I have already made, as well as offering to pay more as I can. Any extra money will be going to this. And so all I'm trying to do is I just want to pay off the debt in full, all $63.41.90. And on their default judgment they filed at the end of June, what they're asking for is $6,725. I'm trying to pay the entire debt off. In total, yes, it has to be made in payments. I own nothing. I'm worth nothing. I literally just want to pay this off and be done. I guess I misunderstood when I didn't know this. I didn't know I could have a judgment put against me for past due debt. So
Ms. Bowers, so when you get sued, it should say this on your initial lawsuit papers when it says you have to file an answer within the Monday after 20 days. That was what you were required to do. And that's why when you didn't do that, that's why a default judgment was taken against you.
okay.
Does that make sense?
Yes.
So Ms. Carter Bennett, I mean, what, and you, I guess response, Ms. Carter Bennett.
So we filed the lawsuit in January. It just took us a while to get her served. We did contemplate, I can tell from the system, we did contemplate, because she was making nominal payments, dismissing it, but the client advised us to move forward, which is what we did because she didn't file the answer. I don't see anything in our note. Had she reduced those payments to a settlement agreement, then we wouldn't be here. So that's what happened. We don't have a settlement on file for her, although she has been making the nominal payments. So I mean, she's still able to negotiate a settlement outside, even though we have our judgment. We are still open to negotiating a settlement with her.
You want to go into a breakout room with her and see if you can work out something?
Sure.
Ms. Bowers, I'm going to send you to a breakout room with the attorney from Discover and see if you guys can put something out, okay?
Okay.
Good luck. And then come back here no matter what you guys do.
Will do. Thank you, Judge.
All right, did you get a notification, Ms. Carter Bennett? There you go. Okay. All right. Mr. Wallace, are you there?
Morning, Your Honor. Yes.
Morning. Sorry for the delay. So I think there was a question I put on your default judgment. It was interlocutory. I guess I just never saw anything in the file, and maybe I missed it, that showed that you had obtained the necessary information to get a default against the individual defendant. It says defendant Calderon has never been served. Let me see if that's changed.
Your Honor, if you look at the docket, it looks like a docket entry of May 11th, 2023. It shows the executed citation return on file for Ivan Calderon.
So do you see that I'm sharing screen? It says returned unserved according to the clerks. You see that?
Yes, that I'm not sure why it says that, because when you click on the actual document, it shows that he was clearly served.
Okay, let me take a look at that. Yeah.
It appears to me, and it was a bit confusing, there was an issue regarding an $8 fee that seemed to be holding up the return being accepted. And I wasn't quite sure what it was for, but we just went ahead and paid it. I don't know if that's why we were getting that entry.
Okay, let me see. Came onto my hand. It says plaintiff never responded to D6 request. I just don't see on the service, if you look at this page, that this was actually served. And maybe I'm missing it. Do you want to share? Do you want to share screen with me where it shows that it's served?
Yeah, I'm looking at the docket. Totals for 5/11/2023 on the docket. Where it says executed citation Ivan Calderon, which is actually interesting. That's what it says on the docket, that it was executed.
5/11. Execute. Okay. All right. Great. It's not. Maybe it's just a clerk error. Let me see. Executed citation. Okay. Yeah. Okay. It's just not included. Okay. All right. It just wasn't included at where it was. It's under the service tab. That's where I was looked. And so apologize about that, Mr. Wallace. Go ahead and get me a new default judgment with the corrected language on it, and I'll go ahead and sign it.
Very good, Your Honor.
And yeah, it's just that I always look at return of service, and that's where it's supposed to be. So
that's quite all right, Your Honor. So
just make sure that you put that this was heard on August 7th. They made a final judgment, and you may want to make a notation in the first sentence that there was a question about the court had a question about service, which was resolved, and then email it to Rhonda as well as Yvonne. But make sure on that first line that it says August 7, 2023.
I will do so, Your Honor.
All right. Good to see you, Mr. Wallace. Hope you have a great rest of your day.
Good to see you as well, Your Honor. Thank you very much.
Thank you. Bye-bye. Okay, our next hearing is motion for continuance Reed versus Rivera. Are both sides here on that?
Good morning, Your Honor.
Yes, Your Honor.
Hey, there's a motion for continuance, and it didn't look like it was agreed. Was it agreed to?
I believe it was unopposed, Your Honor.
Okay. And it's set for trial on the 15th. So both sides wanted me to continue this, I guess.
Yes, Your Honor. I think we actually did. It was followed as an agreed motion for continuance, and we both signed the motion even. So
okay, let's see. Second. And when would you like it reset to?
I would ask for 90 days, Your Honor, because we are just now finalizing dates for depositions of the parties, and we still do need some time to comply with the standing order to mediate prior to trial.
Okay. At least according to the file, it looks like it's currently a non-jury. Usually, this is a car wreck, I assume. Usually, those are. I mean, I don't mind it being a non-jury, but you just may want to follow up on that.
Plaintiff has no issue with that. It would be up to the defense.
Have y'all paid a jury fee? Do you know?
Plaintiff has not and does not intend to.
Nor do we.
Oh, okay. Yes, I want to. Jury, okay. Sounds good. Let's pick a date for you guys. Annoying. Let's see. All right, it's mislabeled. I apologize. See if I can find it. You have a thought on when you want to reset to? About what day?
Today being the 7th of August, Your Honor, I would ask for any date after November 7th. That would work for the court. I don't know if my colleague has any input.
I guess it kind of depends on what dates we're looking at. I have a jury trial the week of November 13th, and I'm almost certain it's already been to the Court of Appeals and kicked back in Tarrant County that we're starting on that week on the 13th. And it'll take at least a week on that case.
I have no objection to any of those dates being excluded.
I can't, I don't know what's happened here. I don't know if it was the clerk's mistake or someone else's, or who made a mistake on this, but I can't find the actual order. It's listed, there's an order listed. I'll show you. Can you guys see my screen?
Yes, Judge.
All right, so if you go here, it says there's an order, but it looks like it's not actually an order. Let me see. Yeah, it's the actual motion is under where the order is supposed to be.
Would you like us to refile an order?
Yeah, if you don't mind. And let's pick a date. You can include the order and the date. So do you want a date that you're more likely to actually go, or do you go to trial, or do you want to just reset it?
I would prefer a concrete date, especially if it's a non-jury setting, Your Honor. I think if we can get one at least 3 months out, we'll be ready to go, if that's okay with the court.
Yeah. How about January 2nd?
No objection, Your Honor.
Let me check one thing, Judge. I know that we. Yeah, that looks like, well, you know what though, that's right after New Year's Day, isn't it? Nobody wants to work that day. I'll get in trouble, but we'll do it.
go ahead and set it on August 2nd, sorry, January 2nd. And hopefully you guys will get it. You said you have not been to mediation yet?
Well, we know we have the mediation, but not since we haven't done depositions yet. So,
Okay. Well, if it settles, let us know. Otherwise, we'll just Rhonda, are you there?
Yeah, yes, Judge. I'm sorry. Ms. Richardson, hold on just a minute, okay? Yes, Judge, go ahead.
So this case, Reed versus Rivera, go ahead and reset it to January 2nd.
Got it, okay.
if nothing else, Judge, I think January 2nd dates probably give the parties a good incentive to get it settled too, right?
That's my thought. All right, guys, you have a great rest of your day. Just give me that order. Okay.
Take care.
Thank you, Judge. Take care.
Okay, are both sides here on the connective agency Texas LLC versus Jackson case?
Yes, Judge. It's good to see you. John Bernard Schwartz here, Your Honor.
Yeah, how are you doing? Long time no see.
I'm no see, Judge. I'm here with my partner, Liz Branning, for connective.
Good morning, Judge.
Good morning.
Good morning, Your Honor. Royale Fraser Lewis here for the defendant.
Okay. Good morning. All right. Okay, Tony, you ready?
I'm ready, Judge.
Let's go on the record on DC 22-150. I'm sorry, DC 23-5148, Connective Agency Texas LLC versus Jackson. Again, counsel, make your appearances.
John Bernard Schwartz and Liz Branning here for connective, Your Honor.
Royale Fraser Lewis here on behalf of Demisha Jackson.
All right, let's proceed.
Judge, this is our motion, Judge, and my partner is going to start presenting. Sorry, Liz.
It's okay. Good morning, Your Honor. We filed this motion seeking limited discovery in response to this TCPA motion that Ms. Jackson filed in this case. And alternatively, if the court's not inclined to grant the limited discovery, we have asked for a continuance of the hearing date by 1 week due to vacations of Mr. Schwartz and myself. And as you can see, he's not in the office at the moment. Initially, Your Honor, we're asking for just a few things with a limited discovery. We would like the deposition of Ms. Jackson, who's the plaintiff in this case, not to exceed 2 hours, and the depositions of 2 non-party witnesses who filed affidavits in support of Ms. Jackson's motion to dismiss, not to exceed 1 hour apiece. We're also asking for limited written discovery, limited to only the communications between Ms. Jackson and the non-party witnesses related to the affidavits that were filed in support of her motion. I did research on the good cause element of this under the CPRC, and there honestly weren't a ton of cases, and the ones that I found often conflated specified and limited discovery with the good cause prong. But I did find one case which is cited in the motion, and it's out of Corpus Christi, called M. Ray Great Lakes. And there the court found that where fraud was one of the causes of action being pled, and where fraud necessarily has an element of intent, good cause existed for allowing the very limited discovery, which I believe in that case was a deposition of the opposing party. And that's what we're seeking here. One of our causes of action that we filed against Ms. Jackson is a cause of action for business disparagement, which requires malice. Now, malice can be inferred, and we understand that under the law. And we do have some evidence of malice on Ms. Jackson's part, but we would really like to ask her specifically in a deposition what she knew, and maybe more importantly, didn't know when she made the online postings about Connective, who is her former employer. And that's really the crux of the motion. Those limited depositions, and then simply the discovery related to the communications between the 3 affiants who filed affidavits in response to the motion. Now, Ms. Jackson has argued that the only reason we're seeking this motion is really to harass her. And that is honestly not the case, Your Honor. We do believe, because of the malice intent requirement, that it would be very beneficial for us to understand what knowledge she had when she made the posts online. And the best evidence of that knowledge comes from Ms. Jackson herself. So as I said, we do have some evidence of malice, but we would really like to explore that more with her. And we would like to talk to the other affiants who are not parties in the lawsuit for simply an hour, take their deposition, and get more information about some of the allegations they've made in their affidavits filed in support. And as I said, if the court is not inclined to grant the limited discovery.
Okay.
Yeah.
Response?
I think she's on mute.
Can't hear you.
Can you hear me?
Yeah.
Okay, apologies. First, to address the motion for continuance, the pre-planned vacations do not prevent them from responding to the motion to dismiss. Mr. Schwartz will be back on the 14th, and Ms. Branning, per her motion, will be in office on the 14th. Her vacations aren't until the 17th and 18th after this, which is after their response date. So the pre-planned vacations do not prevent them from responding to the motion to dismiss. Their cease and desist letter alleges that they have the evidence and that each day they are incurring more damages, so there's no need for an extension. This hearing was set and I was able to respond to the motion for continuance and discovery in a matter of hours. They should be able to respond to a motion to dismiss that was noticed on July 31st and that they still have a week to respond to. Moving to the motion for limited discovery, they have not shown good cause. They state that they need to be able to seek discovery into the subjective statements and regarding Ms. Jackson's intent. Specifically addressing the case that was cited, Your Honor, the court's holding was very specific as to why it granted discovery in that case. The court granted discovery in order to look at the validity of the counterclaim that was being filed, because there was an allegation that the countersuit was a frivolous claim. So the court did not grant discovery to look into the party's intent. It was to look at the validity of the counterclaim. That wouldn't apply to this case here. The court also said in that case that because the party that filed the counterclaim was the party with the vast majority of the evidence, the other party needed to be able to conduct discovery to get to some of that evidence. Here, plaintiff is the one that filed the lawsuit alleging that Ms. Jackson acted with malicious intent. And as plaintiff's counsel just said, they have some evidence of that malicious intent. If they're the ones filing the lawsuit, they have the vast majority of the evidence. So the case cited would more correctly apply to Ms. Jackson's argument that there is no need for them to conduct discovery. The Second Court of Appeals has also stated that the non-moving party would presumably possess at least some evidence, otherwise they would have engaged in sanctionable conduct by filing the lawsuit. At this point, they don't have to prove their case. They just have to provide clear and specific evidence of each essential element, which amounts to more than a notice pleading. So if they are asking the court for the ability to conduct discovery, it means that they do not have the evidence that they claim they did when they filed the petition. Specifically, one of the things that they're requesting is discovery regarding Ms. Jackson's intent. Well, again, if they need to be able to conduct discovery for a cause of action that they filed that they know has a higher intent burden, then they should not have included a cause of action that they did not have evidence for. And secondly, Your Honor, their discovery request is too broad in scope. The TOLA case states that in order to show good cause, the non-moving party has to show how the particular evidence is going to be used in order to respond to the motion. They're asking for the production of the communications between Ms. Jackson, Ms. King, and Devon Anderson related to Connective under the allegation that because they didn't work for Connective at the same time, that must mean that Ms. Jackson posted her review to Glassdoor with malicious intent. That's unreasonable and it's too broad in scope. And the Downer case specifically states that it's an abuse of discretion to grant discovery that is unreasonable because of the TCPA protections with protecting the First Amendment. Across all of their communications, Your Honor, they have accused Ms. Jackson of lying, of having a negative creating a negative work environment, having a negative attitude, and most recently evading service. All of this comes from their petition, their allegations, and initially starting with a review left on Glassdoor. Plaintiff can't show that they have suffered damages, and now they're asking the court to allow them to gather the evidence that they should have had in March when they sent the cease and desist letter alleging that they suffered damages. The vast majority of the evidence that they're seeking is in their control. Their subjective statements that Ms. Jackson made stating that they didn't have an onboarding policy can be quickly controverted by producing the onboarding policy that they allege in their petition that they have. But instead, they're filing this lawsuit and accusing Ms. Jackson of making false statements.
Ms. Frazier, I get it. A response?
Your Honor, could I cut in for just a second? We didn't get to argue the motion for continuance based on my being on vacation right now, because it would be mooted by the discovery. But I'd like to correct the record here. Ms. Frazier is claiming that I didn't have a vacation letter on file. If you look at the Texas Lawyers Creed, Your Honor, I've been practicing law since 1997, and I think you know that I've been around the block a little bit. This is the first time I've ever had to argue with opposing counsel to please let me have a vacation. Yes, our brief is due on the 14th, Your Honor. Totally correct. I get back to town on the 12th or the 13th, depending on traffic coming back from the middle of nowhere, Colorado. I would like to spend some time with my children and not have to, I can't even count on my internet connection. I'm in the middle of nowhere. Our brief is due on the 14th. We ask that the hearing be reset to just the 28th so that I can do some legal research and have a computer that's working. I don't know why it's working right now. I'm just grateful it is. But the Texas Lawyers Creed says specifically.
That's fine. Yeah, Okay. I'll go ahead and reset it to the 28th. I'm going to allow the deposition of the plaintiff for 1 hour. It can be Ms. Frazier Lewis, either by Zoom or in person at your office, whichever you prefer. The deposition of the other two witnesses, you can get their affidavits if you want. I'm not going to allow discovery on that. And Ms. Frazier Lewis, can you provide them 3 dates? I guess what we need to do is, when do you get back, Mr. Schwartz?
I'll be back either next Saturday or next Sunday. I haven't figured that out yet. My kids start school Monday, so I'll definitely be back by Sunday. So Sunday the 13th, I will definitely be back in town.
The deposition will need to take place to August 14th, 15th, or 16th. Which date would you prefer, Ms. Frazier Lewis?
Can we do the 15th?
Okay, we're going to set the deposition on August 15th. We're going to, Rhonda, are you there?
Yes, Judge, I'm here.
So the hearing on this connective agency case, it is currently set on sorry.
It's set on the 21st, Your Honor.
Set on the 21st. We're going to reset it to the 28th.
August 28th of this year? Okay.
Yeah, and we're going to have it at 3 p.m. again.
3 p.m. Okay.
And then Ms. Branning, if you could go ahead and prepare an order on this.
Yes, Your Honor.
That there's going to be a 1 hour deposition. The hearing is continued to August 28th. And anything else we need to chat about?
Yeah, just quickly, we had requested communications between Ms. Jackson and the 2 other affiants. Can we make this like a ducis tecum so that Ms. Jackson would bring to her deposition her communications with the 2 other affiants only having to do with this lawsuit?
Response?
It's too broad in scope. They haven't articulated how this is going to be applied to the motion, how they're going to use this to respond to the motion.
Yeah, I'm not sure how that
show that she has malicious intent in reaching out to former employees to make her own case against Connective, Your Honor.
You can ask her about that in the deposition. I'm not going to allow that. So, all right, guys, give me an order on that, Ms. Brandy. Make sure that the order says at the beginning that this was heard on August 7th, 2023, that you share a copy with Ms. Frazier Lewis, and then that you get this to me by this Thursday. You need to email my coordinator, Rhonda, as well as e-filing it. You guys have a great rest of your day. Have a great vacation.
Thank you, Judge.
All right. Thank you. All righty. Our next hearing is on Equipment Depot, Texas versus Tyndall. Both sides here.
Yes, Your Honor. I'm Brenda Newart. I'm filling in for Richard Wallace with Sheep and Stone for Equipment Depot.
And I'm Daryl Morris here for Tyndall et al.
All right, let's go on the record. Tony, did you get those?
I'm writing them down now.
Okay.
But I'm ready.
All right, let's proceed. Hey, Miss Newart, there's something wrong with your Zoom. Just FYI, I think your camera's messed up.
There is that something is wrong with the camera. If it's, can you see me at all? If not, I will join in on my phone right now. We were trying to fix it.
It's fine.
Well, old school, I realized I can move over to half the screen and I think my face could get.
That's all right. That's all right. You go ahead and proceed.
All right, Your Honor, I'm here on Plaintiff Equipment Depot's motion for summary judgment against defendant Lewis Tyndall, DBA Tyndall Construction, and DBA Tyndall General Contractors. This is a suit on sworn account, breach of contract, quantum merit, and attorney's fees. Your Honor, we have submitted everything for a proper summary judgment, and I'll add that there's no response, but I would like to just go through the evidence here. We have an affidavit of Christy Robertson on file that proves up the facts with copy of all the rental agreement and the past due invoices. What this is, these two parties entered into a rental agreement whereby Plaintiff Equipment Depot would provide rental equipment to the defendant. The defendant would pay for that equipment. In this case, rental equipment was tendered and used and was not paid for. And that's why we're here on sworn account and breach of contract and quantum merit.
Response.
Demand letter. Well, excuse me.
Or go. I'm sorry. I thought you were done. Go ahead.
No, briefly going through the facts, and again, they're all outlined in the written motion with the written evidence before you. In about March of 2017, the parties entered into a rental agreement. As I said, all the equipment was provided, and the defendant failed to pay for that equipment to the tune of $26,717.98. Those invoices are from June 12th of 2020 through November 19th of 2020. So through this motion for summary judgment, we're asking that that amount be paid plus prejudgment interest at the contractual rate of 18% from June 12th of 2020 until paid. The attached affidavit of Richard Wallace proves up $5,050 in attorney's fees, and we were asking for that also. And the main deal here, Your Honor, because defendant did answer, but there's no verified denial, and a sworn account obviously requires under the rules that any account be denied by verification. So to the extent there's any opposition, we have no idea what that's on because there were no verified denials filed. And with that, under Rule 185, plaintiff is fully entitled to summary judgment. And just, the standard, well, under 166 AC,
I've got it.
Yeah, and we've got a proposed order.
Mr. Morris, was no response filed?
No, sir. I've been in communication with Mr. Wallace, and he is aware that I have been instructed to stop contesting this matter. And so I'm just appearing today, so to be here in case anything came up.
All right. Thank you so much. You guys I'll go ahead and grant the motion for summary judgment. I'll sign the order right now. And you guys have a great rest of your day. Okay.
Thank you.
Thank you, Your Honor.
Thank you. Bye-bye. All right. So Tony, Alex, Bianca will be back at 1:30. And
You still live?